Good morning, councils. Before I ask the clerk to call the case, I want to welcome all of you back into the Guam Supreme Court courtroom. I was reminded that this is the first in-person hearing in almost 3 years. And so you're making some type of milestone here with us in reference to the Supreme Court courtroom. And we have very capable counsels this morning arguing. So with that, I am going to ask the clerk to please call the case.
This is Supreme Court case number CRA21-003, People of Guam, Plaintiff Appellee versus Joshua Rivera Palacios, Defendant Appellant. Appearing for the Defendant Appellant is Attorney Braddock J. Huseman and Deborah E. Fisher. Appearing for the Plaintiff Appellee is Attorney Mary Ann Wallachuk. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Huseman reserves 5 minutes.
Thank you. Mr. Huseman, you may begin.
Morning, Your Honors.
Good morning.
Mr. Chief Justice, may it please the court. This case is a murder case. Keith Castro identified Thomas Taitno's brother, his brother's girlfriend, and at least one police officer as being involved in a child prostitution ring. He broadcast this information or this his knowledge of such on Facebook live streams, and he had information or proof of this on an SD card on his cell phone. The victim believed that that information was dangerous to him. He said so on the Facebook videos, and but he believed it was important enough to keep broadcasting, and so he did. On the night of the murder, Thomas Taitno arrived at the crime scene specifically to confront the victim about these Facebook videos and the noise he was making on social media. That night, Thomas Taitno violently assaulted the victim, and at the end of the night, Mr. Castro was dead from a gunshot wound delivered by a bald man. By the way, Thomas Taitno is bald. The victim's SD card did manage, in a roundabout way, it wasn't collected that night, but it did manage to come into police custody. But unfortunately, the police lost that piece of evidence and it was not available for trial. It somehow walked out of the evidence locker. Thus, these facts indicate a strong theory or case for the idea that Thomas Taitno, or his bald associate, killed Keith Castro for the express purpose of the broadcast that Mr. Castro was making and for the evidence he had on his SD card. That story you just heard is Mr. Palacios' alternate theory of this case, but the jury did not hear that alternate theory of the case.
But wasn't the defense able to and did in fact raise the possibility that Taitno had committed the murder?
Sure, it tried to do that, and it was hampered in doing so. And so I would say that yes, there were abilities to nibble around the edges, but the full force of what I just told you was kept out of the court. And the trial court erred in doing so, and it erred for 2 reasons in keeping this alternate theory out. The first is that it used Guam Rule of Evidence 403 to block admission of relevant evidence that didn't, in the balancing test, he abused his discretion in applying the balancing test. The second way he violated Mr. Palacios' rights is through the use or allowing 2 witnesses to claim Fifth Amendment privileges blanketly, violating Mr. Palacios' Sixth Amendment right to counsel or to trial, to call witnesses.
In your briefs in relation to the alternate theory defense, you assert that the trial court erred in reference to its evidentiary ruling in keeping the videos out. First, at 2 intervals, at the 5th day, the argument was that the trial court made a evidentiary ruling, kept the videos out, and then have the opportunity to view all 17 videos, and it was only 5 at that point. But the government points out that by the 10th day, 10th, 11th day, the trial judge had the opportunity to review all 17 videos and based its ruling when it finally had the opportunity to view all 17. You don't seem to concede that point, that the transcripts do not support that the trial judge did in fact at some point during the trial after the 10th day did have the opportunity to view all the 17 videos and thus was in a position to make its ruling. Do you still contend that today?
Well, no, I don't think I dispute that ultimately 99 or 90% through the trial. I think the trial is 12 days. And on the 10th or 11th day, he finally got around to watching all the videos. I don't maintain that he didn't see them ultimately, but I do maintain, and I think this is an error, when you're excluding evidence on a balancing test, if you're not looking at what the evidence that you're excluding, you're a priori not doing a balancing test. But you can hold off your ruling, but that's not what the judge indicated he was doing. He said he was performing a balancing test, and he performed that balancing test on the first day, the second day, the third day, the fourth day, the fifth day,
Yeah,
all
but
the way up.
but that was, you know, the preliminary, and the trial court didn't preclude you from ultimately making the argument that the tape should come in when it finally had the opportunity to view all 17 videos.
Right, and even if, and I do concede that the trial court by the end of the trial had done it, but what I would say is that those 11 days or 10 days, whatever they were, of not viewing them reinforced the idea that he shouldn't let it in. And then I think it's too little too late when 90% of the trial is done. And even then, I think that the court failed in the balancing test. So if you look at the Crosby and War Club cases, the US versus Cosby and US versus War Club cases, those cases indicate that an alternate theory is available to the defendant if it does a few things. One, if it provides means, motive, and opportunity of another individual, and if it answers the question, if not the defendant, who? Well, this evidence provides means, motive, and opportunity to Mr. Tightno.
But didn't the trial court address that argument when it stated that in his mind, the relevance of this alternate theory and that there's some other perpetrator, the videos were really not supportive of that, that the only person that that's identified in the videos that was present at the night of the shooting was Mr. Tom Tightno. And as far as Mr. Troy Torres, Johnny Rosario, they were not present. And so they're, the videos indicating that they may have had some ill feelings towards the victim was really not going to satisfy the Ninth Circuit tests in Crosby, that in terms of means, opportunity, motive, because they weren't present and they can't say that they're the perpetrators.
No,
it can't be said.
I agree with that, Your Honor, except for the point of this, that the trial court was, what he wanted the videos to say was that something more direct than what they did. And that's not the test for evidence. So the test for evidence is there can be direct evidence and there can be indirect evidence. And sometimes, and the Supreme Court teaches this, that the indirect evidence is more valid
But isn't that what all the balancing of 403 is about? I mean, you got to go beyond speculative. And if all you're going to speculate is some third person that may have the means, the motive, and the opportunity, has shown that Mr. Keith Castro was not a well-liked person, that doesn't help the jury identify then who is.
Well, and that is and that question is, I think, part of the problem with respect, Your Honor. So if the idea is that this is some kind of internet beef, then I would concede that point.
Yeah, I'm sorry, I missed that. If what?
But if this was just your standard social media I hate you, you hate me, that is a problem throughout the community right now, throughout the United States, throughout the world. It's the internet. If that's what this was, then that's fine. But if you allow the evidence of what this fight is about, so this isn't a fight about, you said mean things about me in the internet. This fight is about Thomas Taitno has identified and is claiming he has proof, and indeed does have proof of, the victim,
Castro.
Keith
Mr.
Castro.
Keith Castro is claiming he has proof, does have proof, and is publicizing the idea that Tom Taitno, his brother, a police officer, and the brother's girlfriend are involved in a child prostitution ring. Well,
But-
this is.
But even if that's the case and it's there, how does the excluded evidence make more or less probable the possibility that someone other than Thomas Taitno had a part in Castro's murder? I mean, as the Chief Justice pointed out, of all the persons that were implicated in these videos, only Thomas Taitno was identified at the scene. Leighton Borja wasn't there, Johnny Rosario, Troy Torres, none of them were present at the scene. And so how is it that the evidence is going to prove that someone other than Palacios pulled the trigger, or why Palacios was found with the murder weapon? And I think that's what the judge was focusing on.
Sure. And so what I would say is the government's case really does rise and fall on Thomas Taitno. He's provided the eyewitness testimony. Mr. Sablan, the only other eyewitness, changes his testimony after Mr. Taitno comes forward, and Mr. Taitno points out where the gun is and points out where Mr. Palacios is. And when they ask him about it, he says, "Well, I don't want to tell you how I know these things." And so, if you're able, and if Mr. Palacios is able to call into question Mr. Taitno's motivation, because again, remember, Mr. Palacios has no motive according to the government. He showed up, and their case is Mr. Palacios is guilty because Thomas Taitno says he's guilty. That's one way to go with this. But the more you can call Thomas Taitno's credibility into question, and this motive allows him to do that, then there is a very real chance this jury comes out differently. And to one other point,
But
Justice
wasn't
Torres,
there testimony about Castro's postings on social media that was admitted? Some of the videos weren't, but the testimony, and it pointed that Taitno had a motive to commit the murder. And there was also a cross-examination about his sweetheart plea deal. So,
Sure.
you know.
And 2 points. I want to answer that question and then I'll come back to something. But one, yes, but again, those are subplots, because the actual plot is why he's so angry. And why he's so angry is there is evidence on an SD card that there is this child sex ring, right? And it does involve policemen. And that SD card does end up in police custody and then does disappear. And so.
So how does that prove someone other than Palacios or Taitno pulled the trigger?
And that brings me back to the other question I wanted to address with you, Your Honor, is that it doesn't need to prove it. It only needs to raise doubt. That's what Crosby and War Club stand for. It doesn't, even if it's a theory, as long as it's.
So if you look at 401, the standard is more or less probable or less probable that the existence of the fact and is of consequence to the determination of the action. So how would that make it more or less probable, even if all of this existed?
Well, 401 is satisfied under U.S. Crosby and U.S. War Club because it's an alternate theory if it meets those tests. So it's automatically relevant.
Yeah, but
And it
that-
satisfies
that-
401 that way.
That's a pretty broad reading of Crosby and Ward in reference to, they delineated a 3-part test, and it's very focused on if it's not the defendant, then who is it? And so in reference to following up the questions of Justice Torres, that who is it? I mean, the only other person and we're arguing evidentiary ruling here in reference to the videotapes as to what is the issue before this court, that the trial court erred in and excluding, not admitting the video evidence, which then lends support to this alternate theory defense. And so in applying that three-part test, the videos don't seem to identify who other than Tom Paigneau was at the scene, and therefore it's speculative, and it will confuse the jury, as the trial judge seemed to hold. A trial judge did.
Sure. And so you're right, Your Honor. And I'm not saying that those videos, obviously they couldn't implicate an individual at the murder scene because they all predate the murder. But they do give, and it's not just the videos, it's the SD card. It was what was on the SD card. There was direct testimony as to what was on the SD card, pornographic evidence of sexual acts with a child. And that wasn't able to be testified to. And if you look at and this is the problem with the way the court is doing this balancing test. So the court says, well, it's prejudicial. Well, it is prejudicial, the government's case, because the government decided they would go with they brought the case they did, which is it rise and falls on Thomas Paigneau. But undue prejudice is an actual term of art that's used in case law. So undue prejudice is, as an example in this case, if the court would have allowed the testimony as to what is on the SD card and why that SD card is important, right? They're testifying, those are pretty gruesome facts, and but they need to get in. But showing what's on the SD card could also be excluded under 403. Well, that wouldn't be a problem because you're talking, and that's usually how 403 is used. I have these pictures, they're pretty gruesome. I would like to get them in front of the jury. And the trial court says, not today. If you've got something a little toned down from that, we can do that. Or I want to introduce 400 pictures, right? That's the cumulative nature and the timely nature. None of these 403 tests that the court mentioned are actually passed by this.
Well, this case is a little different because we're not dealing with emotions in reference to prejudicial effect. I think that some part of the focus needs to be on the probative value of what you're trying to argue is the value of these videotapes.
Videotapes, the SD card, what's on the SD card, the existence of this prostitution ring. Yes, all those things. And none of those things got in. And it's not just the videos, because the videos could have been used as cross-examination. They could have, and I'm not sitting here or standing here today telling you that's a smoking gun. It's not. But Crosby and Warclub do stand for the proposition that if there is something created to cause doubt, and the government points out in their reply or their opposition brief that too speculative and if there's not a connection, then it doesn't go. And I don't disagree with that case, but that's why we cited Crosby and Warclub, because they indicate that if you can pass that three-part test, right? So Thomas Paigneau's bald. He's at the scene. He's committing a felony. That's means, motive, and opportunity. If I didn't do it, Thomas Paigneau did. Where's bald associate? That's who did it. And the court wasn't interested in any of that. And that's the error. And that's the error in this case. He abused his discretion. And the other way he abused his, didn't abuse his discretion. The other way he violated Mr. Palacios' rights is through allowing witnesses to take a blanket Fifth Amendment. And this is my second point for the day. Mr. Palacios called two witnesses to testify to facts regarding his alternate theory. Again, this is a diminished alternate theory because of the continued pruning by the trial court of what can and cannot be said. But they were called to testify as to the actual existence of this feud, why it existed, that they called the victim a snitch, and that one of these witnesses actually paid or was attempting to pay to get a hold of the SD card after the murder, which again goes back to this motive. Why would you need the SD card, right? There's a reason for these things, and it's all being kept out by the trial judge. Yes.
Who was going to testify about this?
The SD card would have been Ms. Rosario, I believe, Johnny Rosario. I believe that's what she was called, and I believe that was the offer of proof. But for both of these witnesses, Troy Torres and Johnny Rosario, on the interrupting the first question to them, they announced that they were going to take a blanket Fifth Amendment privilege and that they didn't want to testify. And the trial court actually set out the correct standard in the record, like, well, we'll go question to question because that is the standard. But then something happened. The prosecutor starts objecting, wants their rights protected, and the trial judges gets, I don't want to characterize what the trial judge did. I'll just say the trial judge decided to release the witnesses. It was literally a get out of testifying free card. And the government and Mr. Palacios both agree that is not the standard. It's just not the standard at all. And so in this case, the only way the trial judge could have done what he did is if he knew what they were going to testify to, but he didn't. And he knew that they were going to testify to criminal acts. But the trial court can't have it both ways. So several times during the trial judge told the trial counsel that they had that his alternate theory were dull arrows, or that his alternate theory isn't available, not here, not now. Okay, well, if it's dull arrows and it's not a great theory, then why are these people in jeopardy? Why are they in trouble? What reasonable apprehension do they have to be prosecuted on a dull arrow, not very useful theory? And he allowed them to get out of testifying, and and the government says that this is about drugs, but that's not what the proffer was about. And 403 would be an excellent use of keeping those kind of questions out because they wouldn't be relevant drug use. They don't need to invoke their Fifth Amendment on something like that. They could have used 403, and certainly the judge knows how to invoke 403.
Was there any off the record discussion about immunity or other means to address the Fifth Amendment issue?
The only thing I have, and I wasn't trial counsel, Your Honor, and the only thing I have is what's in the record. And half the time, and I think I put this in my brief, the record isn't necessarily clear because of the COVID precautions the court was taking. Some of the crosstalk is just noted as crosstalk, but it doesn't appear that there was anything off the record. I'm not aware of anything that was off the record. And at one point, the trial counsel for Mr. Palacios does ask that this go in camera, and that there needs to be some kind of assurance. The court needs to understand that they're about to invoke their rights for a real reason. And if the court had done that, and the reason they're invoking the rights is because they are in a plot to murder Keith Castro, well, then the court would have been alerted to the fact that what he's excluded in the previous bunch of days actually was relevant, actually mattered, and is a problem for him all of a sudden. But the easier thing to do was to excuse them right away, and that's what he did. And he violated my client's Sixth Amendment right to call witnesses.
Yeah, but let's assume that the trial court did err in doing the blanket immunity. Again, Troy Torres and Johnny Rosario were not present at the scene at the night of the murder. So they couldn't provide testimony in relation to what occurred, who was the perpetrator. Again, it just goes then to your third party alternate theory in terms of motive, opportunity, and that someone else did it. But if Troy Torres and Johnny Rosario were not present at the scene, and they couldn't, and the court had before it the testimony of Tom Tightno, testimony of Matt Sablon, the weapon under the mattress of Mr. Palacios, what was the harm? I mean, how is it a harmful error that the court kept out the testimony of Torres and Johnny Rosario?
We kept out the ability to raise doubt. That's the problem. If she testifies that I need to take the Fifth Amendment because
but the doubt that you wanted to create was that it was someone other than Mr. Palacios, obviously, that it was some bold person. And there was already testimony when Mr. Tightno took the stand that he was subject to cross-examination, and his hair was shorter than Mr. Palacios. And so the jury had all that information when it ultimately rendered its verdict.
And if the jury would have been impaneled, and if I don't know what the I don't know what the trial counsel's actual questions were. I only have the offer of proof, as the court does. But if the trial counsel says, well, Thomas Tightno actually committed the murder, didn't he? And he committed the murder on your behalf. You wanted him to. I'd like to take the Fifth Amendment on that. Well, all of a sudden there's immediate doubt. And that's what they were called for, to testify to the underlying problems with, again, there is no motive for Mr. Palacios, but there is a motive for the star witness, and almost all the evidence rises and falls on Thomas Tightno. And that is the harm. That is the harm, Your Honor.
But if you were to answer, I'm taking the Fifth, isn't that the whole purpose of the court? It's not putting a witness on the stand to ask question after question when they say I'm taking the Fifth.
Well,
So then it creates doubt just through the questioning, whether or not there's any factual basis.
sure, it could create doubt if and we've put that in our reply brief, which is if they're taking the Fifth and it's over and over and over again, and you're making them do it, and it's not about their drug use, but about what happened, the underlying facts of why they might wanted to have the victim dead. Well, then, and if they start taking the Fifth Amendment on those kind of questions, then yes, I think that obviously goes right to why they needed to testify to each question and why they had to sit to an answer. And that's why we forced them to do it, because as we pointed out in I think it's a Ninth Circuit case, where the jury is entitled to see an individual. The Fifth Amendment has burdens and benefits. The benefit to you for taking the Fifth Amendment is that you don't have to testify to yourself, but there are burdens that come along with those rights. And the trial court let the witnesses off without any burdens, and to the detriment of my client's Sixth Amendment right.
I just want to point out that you have 50 seconds, and so you may want to reserve that for your rebuttal.
I do want to reserve that. And the only other issue is the jury excluded over 65. And we've provided a case on that, and we think that it's right on point. It's the same problem, but I'll reserve whatever remaining time I have. Thank you, Your Honor.
All right. Thank you, Mr. Houston. Assistant Attorney General Wallace.
Chief Justice, may it please the court. The defendant here is asking for another opportunity to present a defense that he never made a proper case for in the first place at his trial. So the people are going to ask this court to affirm the judgment below. We'll address the first issue here, which is the opportunity to present a defense, and then the Fifth Amendment, and then I will address the jurors 65 and over. In this case, the defendant had ample opportunity to present a plausible defense, but that's not what he's asking for. He's asking to present a defense that's not plausible. We have to start here with the rules of evidence, and the rules of evidence.
Why do you say it's not plausible?
Okay, Your Honor, I had a whole list of things about why it's not plausible, and that's because there are eyewitnesses who saw what was going on that night at Matt's parents' house. So what was going on was that Keith Castro was being beaten up by two men, one of whom was Mossy Tightno, and the other one was Josh Palacios, the defendant. He was identified by Lala Vasquez, who was there. I think that Melvin Leon Guerrero saw him with a gun. Matt Sablon also eventually made a statement to this effect. So it's not just Mossy's testimony that is putting Joshua Palacios on the spot. It's also these other witnesses who are able to do that. And so under 403, the court can exclude relevant evidence if its probative value is substantially outweighed by all these risks that are listed in Rule 403.
What about, one of the things that's a little troubling is the testimony that other witnesses had discussed planning evidence. And couldn't that have helped the theory that the defendant's theory that the gun might have been planted under his mattress? Because there was these discussions between I think it was Leighton Borja and Taitano about planting evidence?
I don't think so, Your Honor, because he was seen, for instance, by Lala. Lala saw him standing next to Keith when Keith was on the ground. And the medical examiner said that the trajectory of the bullet is from somebody who was standing over the victim and shooting him. And he's the only one who was seen with a gun. So as for the beating, yes, Thomas Taitano participated in that, but there's only one person there who had a gun, and that was Josh Palacios. And so I don't think this planting evidence stuff leads to anywhere. And in fact, you know, the gun was found under a mattress that Joshua Palacios was sleeping on with his girlfriend. You know, it's a place where he was living, and that gun matched up to the bullet that was taken from Keith's body. So the theory that the defendant has to present, it's got to be plausible, and it's got to explain things. Like a good theory will explain everything, and maybe you can't explain everything in this case, but you've got to explain some things, and this doesn't take that into account. If it was some other bald guy, who is he? Where did he come from? Where did he go? How come Josh is the one who has the gun? How come Josh is the one who was seen with the gun? Why is Josh the one who was there that night and people identified him? So it's not some other guy who's bald. Also, there was testimony about whether it's some bald guy, and the defense was provided with discovery. And if you look at the photos of the mugshots of these two men, they've both got very short hair. So the trial took place a year and a half later, but it's just not credible to say that, you know, one is bald and the other is not. They both had kind of similar hairdos, which is very, very short hair. I think it's called a fade. So you can kind of see your scalp through your hair when it's that short. But it's not exactly bald, but that's the description that Matt Sablon chose to use. Another,
But even if the government has this overwhelming case that you're arguing about, doesn't the defendant still have the right? Basically, he was going to attack Taitano's credibility. Doesn't he have that right to present that theory?
and so he did attack Taitano's credibility because he was able to cross-examine him and ask him all kinds of questions. You know, in this case, I think the way the defendant was trying to get the videos in is very improper. He showed up with, I don't know, 10, 20 videos on, you know, day one of the trial. And these are videos that have been posted in July of 2019. The trial is in January of 2021. So it's a year and a half later. Why are we finding out about these videos just at the last minute? The defendant had all this time to work on them and didn't.
But the government didn't object at the time that was the reason why it was objecting to the evidence.
Yes.
And didn't ask for more time to review the evidence, but just proceeded to trial.
Yes, because the government identified some problems with those videos that the defendant should have worked on overcoming. The defendant filed a written motion. They said, you know, there's no proper foundation. There's no authentication of these videos. How do we know that that's Keith Castro in the videos? His face is covered. He's wearing a hat. He's wearing sunglasses. You know, sometimes he's with a person. Who is that person he's with? He's driving around with somebody. Why didn't Joshua Palacios get that person to testify and say, I know this is Keith and this is what Keith was saying? Like, I think that the defense counsel just expected to be able to present these videos without.
And as I recall, I mean, the government, I remember reading somewhere in the record, did file a motion in limine as to these videos after they were produced at, I think, the first day of trial. So there was an opportunity for the government to object to these videos, and then that's what proceeded with these piecemeal decisions on the part of the trial court.
Yes, Your Honor, that's right. And, you know, the court the trial court was not able to see them all at once, which is why the trial court did not make a ruling at first. You know, it waited until it got to see all of them. And so, you know, we dispute what the defense is saying, that the trial court never saw the videos. It actually did see the videos. It watched them little by little. And, you know, it's because the defense presented them so late. Maybe if it had done it sooner, the trial court would have come out with a ruling sooner. The other thing that the defendant never did is he didn't have some post-trial motion about this. You know, he had up until the end of trial to make the trial court change his ruling. The trial court could have changed his ruling and maybe let those things in, but the defendant had all this time and never made a showing that would convince the trial court that this would be a good idea, that it wouldn't confuse the jury, that it wouldn't cause delay, that it wouldn't confuse the issues, that, you know, all these things that are under Rule 403.
Was the defense able to comment on the videos in reference to its closing argument?
Yes, and I believe he did, and even though he didn't present those videos to the jury, so he was able to talk about them in any case. Also, 403 has to be taken into account with Rule 602, which is, you know, the witness testifying has to have personal knowledge. So I think I mentioned that there were other people sometimes in these videos who could have testified to their authenticity. For instance, Heather Fulcher testified, and she was in one of the videos. Like, maybe not one of the videos where it talked about the kinds of things that the defendant is trying to say happened, but, you know, she was in one of the videos. And then, you know, if the defendant had done more investigation, maybe he would have found out who was driving the car those times when Keith Castro was doing a Facebook Live video in the car, but he wasn't the one who was driving. So these are things that the defendant could have done, and he didn't do them. You know, the defendant is allowed to present evidence and argue a theory, but he's not allowed to present a theory. He's supposed to present evidence. You know, the government has to prove beyond a reasonable doubt that the defendant committed a crime, and the defendant can create reasonable doubt in the jury's minds, showing that somebody else is responsible for this crime. But he's got to do that with non-speculative evidence that comes in through witnesses who have personal knowledge, and it's got to be consistent with Rules 403 and 602 before the defendant can argue, hey, it was some other guy who did it, some bald associate of Mossy Titano's. Okay, just in case I didn't tell you all the evidence that the government had that shows that this is why Josh Palacios did it. You have Matt Sablon and Lala Vasquez. They saw Mossy and the defendant beating up Keith Castro. Lala says she saw the defendant with the gun. That night, she told the police that. And then later on, she made a written statement to that effect. And then when she was testifying, she was a little bit wishy-washy, but she eventually did come out and say those things. She's the one who saw the defendant kind of standing over Keith when Keith was on the ground. And I think that's when Keith got shot because of the trajectory of the bullet that the medical examiner talked about. And Keith died of a gunshot wound from that bullet. And that bullet matches the kind of bullet that comes out of the gun that was under the mattress of the bed that the defendant was sleeping in with his girlfriend at home. So, I also want to distinguish the two cases that the defense raised, which are War Club and Crosby. So those cases are not the same as this one, because in those cases, for instance, in Crosby, you could easily say that, hey, the husband is the one who did it. So the defendant was on trial for some sort of assault, but the evidence showed that the husband was in the area. He had previously been violent towards his wife and he had beaten her. And he was angry with her for having a relationship with that defendant. And there was little direct evidence of what had happened. And plus the victim kept changing her story. So that case is distinguishable from this one because this one is much clearer what happened. And similar to the War Club case, you know, the defendant wanted to present evidence that his brother ordered the killer to commit the murder. And the court said, no, you can't do that. And it turned out to be the wrong decision. The court abused its discretion. It should have allowed him to do that because there was a basis for asking those questions, whereas there's not really a basis for asking them here. And since there's no abuse of discretion, the court should affirm. I'm going to turn now to the Fifth Amendment issue. You know, the standard of review here is abuse of discretion. It's not de novo, as the defendant states in his brief. That has to do with the defendant's right to remain silent, those cases that were cited. So this is a third party. This is Troy Torres and Johnny Rosario. They're not defendants. So this is a decision that belongs to the trial court, and it goes with abuse of discretion.
While they could have made or claimed the Fifth Amendment for the drug use, for example, why couldn't they answer the questions about the alternate theory that was being advanced?
You know, the person who would have cross-examined them if they testified to their drug use and stuff would have been a prosecutor. So they would be in some kind of trouble. And the court knows that because the court watched their 37-minute video.
But if they're not going, while that may be a legitimate basis to assert the claim on the drug use, what is the basis for asserting that claim on the alternate theory of someone other than Mr. Palacios being the triggerman?
You know, I'm just speculating here, but like maybe it puts them in danger that, you know, they know something and now everybody knows they know it. And then what if they testify?
That's not a basis for claiming the Fifth Amendment. I mean, it's the, you know, potential for criminal incrimination, not that someone's going to be unhappy with your testimony and be angry.
Yes, Your Honor. And so, in this case, the defense told the trial court that he wanted to probe Troy Torres's criminal liability. So no wonder Troy Torres said he's going to assert the Fifth with every question, you know, if somebody is probing his criminal liability. So taken together with that and the video that the court watched, the court had enough to go on to allow these witnesses to assert this privilege. And I would argue that Johnny Rosario sort of is similarly placed to Troy Torres because she is in the video with him. So her reasons for asserting are kind of the same as Troy Torres's because, you know, they did that video together and they have the same reasons for asserting the Fifth Amendment privilege.
Was there any discussion of privilege or immunity for the testimony given during the trial?
You know, Your Honor, I didn't see anything like that in the record, and I don't know. So I don't know. There's nothing like in the. I don't see anything in the files or anything like that. And nobody put it on the record before the court or talked about it. There weren't any motions or agreements or anything, things like that. And
So
since
do you concede the proper procedure wasn't followed here?
The proper procedure, you know, if somebody's going to assert the Fifth after every question by question, then I think the court does not need to test the witness. If he says he's going to do that, the court can believe him and doesn't have to put him on in front of the jury and watch him do that. So I wouldn't say
But
that the procedure was improper.
Was one question enough?
Sorry?
Was one question enough to make that decision?
Because one question was enough in this case, Your Honor, because the circumstances are unusual, which are that the defense said I want to probe his criminal liability. So, you know, there was already some question there that he had, you know, he was in jeopardy of being charged criminally. So that's why we would say that. And since there's no abuse of discretion here, we're asking the court to affirm. Finally, I want to address the thing about the jurors being over 65 and automatically excluded. I went over the record again, and that's not what happened here. We don't have any record that jurors over 65 were automatically excluded. What we have is a statute that says if you're over 65, you can choose not to serve. Other jurisdictions have had these kind of statutes for years, just like we have, and they're constitutionally okay. The
But
case.
isn't the argument that there was a promulgation order that excluded jurors over the age of 65 from having to attend? Not that they had an option to opt out.
Your Honor, there was a question by the defendant. So I guess it looks like the defendant didn't find out about this until the defense counsel didn't find out until a few days into trial. And he asked the court, is it true that people over 65 are automatically excluded and they didn't have to show up? And the court said, the court didn't actually give him an answer. There is no answer on the record where the court says, yes, people who are 65 and over were automatically excluded and they didn't have to show up. So I can tell you where in the record that is. It's excerpts of record, pages 114 to 116. And that was on trial day, January 25th, 2021, pages 63 to 65. So during those, you know, during that short, you know, exchange between the defense counsel and the trial court, you know, the defense counsel was asking, did this happen? The court said, I don't really know. Why don't you put your motion in writing? And I think the defendant never put anything in writing, and he said, I'm ready to proceed. So they proceeded with trial. So they must have been okay with what happened here. Not only that, but when you're picking a jury, I believe you are, you know, the procedure is that you are given a list of prospective jurors, and it's got information about them. It's got their names and like what village they're from, and it's got their ages on it. So if the defendant thought that people had been excluded from the veneer, why didn't he present that to the court and say, here, look at this, people over 65 were automatically excluded? And then at least the court would have something to look at. But in this case, the court had nothing to look at. And then I think the defendant also said that, you know, about the jury commissioner's memo and the policy or whatever, he said the court was going to give him that. The court never said that. The court said, I think there's been some discussion and stuff, but he didn't say, I'm going to get you a copy. So I filed a copy of what that was with a motion for judicial notice. And the way I got it was a FOIA request. And that's something the defendant could have done too. Or maybe since he was in that very trial, he could have just asked the jury commissioner and said, you know, not just for a sample, but give me the real thing. Give me the questions and answers that people actually gave in this case of mine so that I can see who didn't show up. And then the other thing is that, you know, as to the religious issue, which we're not going to address today, but, you know, the defendant, he did an interlocutory appeal about that. And so why didn't he do something about this before the case was over? He could have done a post-trial motion. He could have gotten the trial court to say, oh yes, all these people were excluded. You know, we need to do this over. But he never did that. You know, he just, it seems like he abandoned the claim and he never made the record. So I think maybe this issue was waived. And therefore, since these people were not excluded from the panel, the defendant didn't suffer any constitutional violation under that showing under the Duran case from the US Supreme Court. And so this court should, you know, affirm the decision below. And in the alternative, we presented a bunch of statistics that show that people who are 65 and over were actually 4 times at 4 times greater risk of perishing than younger people. And so this court had the judiciary had a good reason to allow people in that position not to have to serve jury duty. So, Your Honors, we're saying that the trial court did not abuse its discretion in this case. The defendant didn't suffer any constitutional errors, and we are asking that the conviction below be affirmed. Thank you.
Thank you, Ms. Wallace-Chuck. So Attorney Huseman, I will give you 2 minutes and you can wind up your arguments.
Thank you, Your Honor. With regards to the 403 issue, nobody saw who actually shot the victim in this case. The only testimony we have was a bald man and Thomas Taino's testimony. And the idea that Mr. Palacios cannot put forward especially when there's no motive, the government hasn't provided a motive on his side, when Mr. Palacios can provide means, motive, and opportunity for Mr. Taino to be the actual trigger man, and not to be able to put on that information. And that evidence is, we think, an abuse of discretion. As far as the Fifth Amendment, I know that the government and Mr. Palacios disagree on the standard. We cited to a Guam case. They cited to the Ninth Circuit. I can provide the court with additional California Supreme Court precedent where the standard is for the Fifth Amendment claim is de novo. That is People v. Seijas, S-E-I-J-A-S, at 114 P. 3rd 742, and People v. I'm not going to be able to pronounce this, Trujeque at 349 P. 3rd 103. Those are both California Supreme Court cases. They involve exactly the situation here, which is a blanket Fifth Amendment protection, and the conflict between a Fifth and a Sixth Amendment tension there. And finally, since I didn't really address much of it on opening, I'll just talk to the juries excluded the 65 over 65 Monumco. So Justice Torres, you're completely correct. The law here is that people who are over the age of 65 have the choice to exclude themselves from jury. So they're an identifiable group. They were excluded not by their choice, but by the government's choice, right? And this idea that my client's attorney could have done FOIAs during the middle of trial and is just not correct. The trial is going on. There are a million things. It's a fire hose. Anyone who's done a trial knows that. And as far as the record goes, I want to correct that. So on 114, Mr. Fisher says, Your Honor, there's just something I wanted to bring the court's attention. Maybe you could give me some clarification. Court says, sure. During the lunch hour, I learned that the jury commissioner actually pre-screened jurors and eliminated those jurors who are, I guess, 65 or older. Did the court know whether or not that is true? Court, that's my impression. I think the COVID-19 protocols, they don't want anyone that's had these, preconditions, comorbidities, among others. My understanding is that they were limited, was just based on age. Age is not a comorbidity. If the court is confirming that in fact did happen, I'd move for a mistrial. And then he goes on to ask for the memo, and the judge is like, I don't know if it's a memo, but if there is, I'll get it to you. And there's more discussion about that. But the idea here is, and it's just like in the Alabama case we cited, it's the exact same fact pattern.
Well, let's assume that you proved a prima facie violation. What about the fact that there's still a reasonable exemption that advances a significant state interest, and that is to protect the elderly from COVID-19? I mean, so even though you say, okay, they're a distinctive group, there was underrepresentation, the representation was not fair and reasonable in the veneer, but you still have the exemption. And why isn't that a bona fide exemption to, and not put it in the position of, well, they can decide when they come here, but recognizing that even the travel potentially might pose a risk to them. And so there's an advancement of a significant government or state interest.
And I would say that the problem with that, and I would concede all those things. These people are special and they need to be protected, but so are people with diabetes. So are people that do have comorbidities. And if you look at the filing the government made that asked the court, and we don't have an objection to that, to take
So you're
judicial notice.
suggesting that if there is a policy that's enacted to protect a certain group, an at-risk group, you have to do it for all at-risk groups?
Yeah, I would say that that is the case because you're dealing with the jury. And if you look at the letter that went out from the court's clear that this is how we work our democracy. The jury service is important. And the court has pre-screened a group of people, a selected group of people. And I don't dispute the science on this, that they suffer more adverse consequences from getting COVID, but so do people with diabetes. So do people with BMIs that are 2 standard deviations. So people with, gout and respiratory problems and heart problems. And the community is filled with these kind of people. This was a uncertain time, and this was an easy thing to do, and I freely admit that. But we're talking about a right, and if you look at the letter that went out from the court's real clear that this is how we preserve our democracy and our rights, and jury service is important. So it didn't ask if there were any comorbidities that the individuals who received that letter did. And those letters, presumably, according to the judge, didn't go to people who were over the age of 65. And that's why we've made this point, and we believe we're entitled to a new trial. And any of these 3 issues entitle Mr. Palacios to a new trial. We would ask the court to reverse the trial court's decision to grant a new trial and remand for further proceedings.
Thank you, Mr. Huesman.
Thank you, Your Honor.
Thank you, counsels. The court will take the matter under advisement. Just for the convenience of the court and counsel, you cited some cases that you didn't have in your brief. You could provide that in letter form and serve Ms. Wallace-Chuck.
Yes, Your Honor.
We're not asking for any additional briefing.
Won't be any additional.
And that was for Ms. Wallace-Chuck more.
Sure.
Okay. Thank you, counsels. And the court will take the matter under advisement.